Next, from Springfield, Mark Denzler of the Illinois Manufacturers Association is joined with Bill Bodine of the Illinois Farm Bureau and others as they hold a press conference to denounce legislation that they say will further slow down an already cumbersome state permitting process by allowing any person, including non-Illinois residents, to sue state agencies. This runs about 25 minutes.
Good afternoon. My name is Mark Denzler. I appreciate you being here today. I'm the Vice President and Chief Operating Officer of the Illinois Manufacturers Association, joined today with the Illinois Farm Bureau, Illinois Association of Aggregate Producers, the Illinois Chamber of Commerce, and the Illinois Petroleum Council to shed some light on two bills that are currently making their way through the legislature, House Bill 5119, Senate Bill 3005. Before I get into the substance of these bills, I'll preface my remarks by noting that many of you heard from the IMA before and others up here about the costly and burdensome mandates that are imposed by the General Assembly on our respective members and the negative impact they have. From the manufacturing sector alone, since the recession ended, Illinois has added 8,300 new manufacturing jobs since 2009. Our neighboring states during that time period have added an average of 68,600 new manufacturing jobs. Every one of our neighboring states have added at least twice the number of manufacturing jobs to Illinois. This year, environmental activists are pushing legislation that would allow anyone in the world, not just in Illinois, to weigh in on permit decisions issued by Illinois agencies. No longer would a person have to live in Illinois or be an impacted party. They simply have to be, quote unquote, adversely affected or aggrieved. For example, a person in California could claim that expanding Interstate 355 will add more cars to the road and increase emissions. A person in Indiana could claim that spraying for mosquitoes to control West Nile virus impacts air quality negatively. While they call it, quote unquote, judicial review, it specifically allows a person to provide new or additional evidence to the court. This is not a review, meaning they get a second bite at the apple. For years, Illinois businesses, manufacturers have complained about the cost and time to get permits in Illinois. This legislation, if enacted into law, will add further delays and greater cost, resulting in less economic development in the state of Illinois. It will clog our court system and add years to the already extremely long permitting process. This impacts things like road projects, manufacturing expansions, family farms, youth camps, campgrounds, swimming pools, non-community water systems. There's a whole host of things that could be impacted. You're going to hear from some of my colleagues up here. The list goes on, but it applies to any administrative decision by one of 5 state agencies: IDOT, EPA, DNR, Public Health, and Agriculture. Anything that impacts public trust in waters and land, state parks, natural areas, surface, groundwater, or other matters affecting a healthful environment. With that, I'm going to turn it over to Bill Bodine at the Illinois Farm Bureau.
Thank you, Mark. My name is Bill Bodine. I am the Associate Director of State Legislation for the Illinois Farm Bureau. And the Illinois Farm Bureau does oppose these bills because they will have a devastating effect on farmers by exposing them to lawsuits by those who disagree with administrative decisions made about their farms. Illinois agriculture adds $120 billion of activity to Illinois' economy. We support over 400,000 associated jobs. So agriculture is an important economic engine for this state. But unfortunately, these bills come at a very difficult time for our farmers. In February, the USDA reported that net farm incomes for 2018 are estimated to be at their lowest level in the last 12 years. And if those estimates are accurate, this will be the 4th consecutive year of declining income for farmers. And so now we have bills that have been introduced that simply add a layer of costly and unnecessary lawsuits challenging the approval or decisions made about farms by state agencies that are likely to grind economic development for agriculture to a halt, and at a time when farmers can least afford it. Now, the bills add a layer of these costly lawsuits and have very broad implications. They could impact a number of decisions made about farms. One that we'll use as an example is they possibly could impact the approval of the construction of a livestock farm by the Illinois Department of Agriculture. So as Mark Denzler explained, any person who feels they've been aggrieved or impacted by that particular approval of the construction of a livestock farm, no matter their residency, could sue because they have that concern with that particular decision. And this could be someone located far from the farm location. Now, if you're a farmer maybe you're interested in expanding your operation, you want to build a livestock barn to possibly bring back the next generation, your son or daughter, to that operation, you're likely to face lengthy delays, you're likely to face construction costs, and you're likely to face very costly legal defense of that particular administrative decision. And there is already a legal remedy available to people who may be directly impacted by the construction or operation of a farm. Farmers may face what are called anticipatory nuisance lawsuits from those who may feel they would be impacted by, say, the construction of that livestock farm, or they, once that farm is in operation, may file a nuisance lawsuit if they feel that operation is impacting their particular property. So there's already legal remedies available to people. There's also very strong regulatory processes already in place. Again, using the example of the livestock farm, there are two levels of regulation that livestock farmers face. The first is a level of regulation that addresses the location, design, and construction of that particular livestock farm, and then a second level of regulation that addresses the operation of that particular farm. Any violation of either of those levels of regulation means the possibility of enforcement or fines for a particular farmer. So there are strong regulatory protections already in place to protect the environment. So again, the bill adds a very costly and unnecessary layer of additional lawsuits that will further erode the economic climate for agriculture in the state of Illinois at a time when farmers are struggling and can least afford it. With that, I will go ahead and turn it over to Dan I Colts with the Illinois Association of Aggregate Producers.
Thanks, Bill. Good afternoon. I'm Dan I Colts. I'm the Executive Director of the Illinois Association of Aggregate Producers. We're a trade association that represents producers of crushed stone, sand, and gravel that's used in construction materials such as concrete or asphalt pavement. My members operate over 300 mines in Illinois. Most people live within a few miles of an aggregates facility and don't even know it. Because this is a low-cost, high-volume material, the majority of cost for aggregate is usually the cost of transporting it. So aggregate sources need to be near where construction takes place. Most of the materials my members produce is utilized in transportation infrastructure. Illinois is a vital transportation hub with the third most interstate highway miles, as well as key airports, railroads, and river networks. The construction of transportation infrastructure supports more than 129,000 full-time jobs in Illinois. Senate Bill 3005 or House Bill 5119 would be a jobs killer. Obtaining the necessary permits and zoning approvals to operate a mine in Illinois is already a very cumbersome and lengthy process involving extensive public input. This legislation could add additional layers to that process. Illinois is more dependent than ever on federal funding for transportation infrastructure, and obtaining federal funds is often a competitive process with the federal government seeking shovel-ready or near shovel-ready projects to fund. This legislation could severely hamper Illinois' ability to get federal funding, whether it be for adding another lane to a congested road or maintaining one of our crucial lock and dams. I also want to point out that many of the infrastructure projects that this legislation could delay or stop, such as projects to improve the safety of our roads, are vital to the safety of our citizens. So with that, I'm going to turn it over to Kelly Thompson on behalf of the Illinois Chamber of Commerce.
Thank you, Dan. Good afternoon. I'm Kelly Thompson with the Illinois Environmental Regulatory Group here on behalf of the Illinois Chamber of Commerce. As with all the organizations here today, the Illinois Chamber of Commerce is in opposition to Senate Bill 3005, as it would further increase the cost of doing business here in Illinois, hampering the growth and development of business throughout the state and new businesses looking to locate here in Illinois. The bill could be used to intentionally stall and cease business growth in Illinois by creating excessive litigation, which further undermines the business's ability to move forward in obtaining the necessary permits and approval of projects to build and operate in the state. Illinois' permitting process is currently structured to allow for public participation, including public comments, which undergo a thorough review by a respective agency prior to any administrative decision being made. The permitting process takes months to years before a business receives a permit to operate or construct, not to mention the excessive costs associated with receiving those permits. If Illinois adopts the bill into law, this would add an even more financial burden to an already overtaxed business community, including additional legal fees and increased uncertainty associated with the judicial review. To further explain, most state-issued permits for activities that could have some type of environmental impact already have terms and conditions built into the permit. These additional terms are to ensure protection of the people and the region of potential impact. The permits are issued consistent with statutory and regulatory requirements adopted by the legislature and state agencies. Permits are issued by qualified professionals to which all aspects of the permit application are reviewed and verified prior to issuing the permit. The Illinois business community supports a flourishing business environment where jobs are on the rise and consumer prices are low. Along with the other organizations standing here today, the Illinois Chamber of Commerce is in opposition of this bill. Thank you.
We're happy to take any questions at this point.
Have you talked to the sponsors on this, and have they relayed to you why they're looking to change what you guys are saying is already a system set up to allow for people to challenge permitting process?
Senator Raoul and Representative Anderson are the sponsors. We've talked to them. Interestingly, the original bill impacted any decision made by a state or local entity. So a city, for example, a county, they have limited it to 5 state agencies now. We're still in opposition to it. This is going to chill economic development, and as Kelly and Dan and Bill have already said, there's already a process in place. There's already a process in place for stakeholders to weigh in, as you know. If you're getting a fracking permit, you're getting a road permit, a new manufacturer is being built, there is already a process in place to handle that. This legislation adds a new layer that allows anyone in the world to weigh in through the judicial system, adding cost and delay. So we're greatly opposed to that. We're here to express our opposition and hopefully stop the bill this session.
Can you unpack that a bit more, saying anybody in the world, just looking at a brief synopsis of the bill, it seems to change parties to persons? Mm-hmm. Can you explain that?
So the definition of anyone who is adversely impacted. So for example, my example of somebody's in California and Interstate 355 is being built and they're adding an additional lane and they say we're going to add 25,000 new cars to the road. The person could allege that increased air emissions have a negative impact on air quality, therefore they're negatively impacted and they could sue. The second problem with this is that it allows new fact patterns to be used. It's not simply a review of what the EPA did or IDOT to say, did they follow the law? Did they take testimony? Did they weigh in appropriately? This allows them specifically to add new facts, new legal arguments, so essentially a second bite at the apple.
And then it'll cost businesses, farms, and so on, but who would benefit from this, aside from those who are trying to challenge and for whatever environmental reasons? Is this something that tort lawyers are chomping at the bit for?
I think this is being pushed by environmental activists that, quite frankly, want to stop projects and growth in the state of Illinois. I don't think that they want, for example, fossil fuels to be burned, so they may try to slow down pipeline expansion. They may be adverse to family farms and certain practices that are used. They want to slow those down, and they just don't want it to happen in the state of Illinois. And I think consumers are going to pay more. I think you've heard here, there's going to be less business development, increased costs are going to go on, increased litigation. We think it's going to be a big loss for the state of Illinois.
Bill, do you happen to see this as an end around to trying to change the LMFA without actually changing the LMFA by groups that might be opposed to it?
Well, as I mentioned, the legislation as drafted would have broad impacts on farmers, but one of the areas we think could be impacted, yes, are the approvals of livestock farms by the Department of Agriculture and could be used to undermine those decisions that occur under the Livestock Management Facilities Act. Yes.
So let's, devil's advocate, Illinois might have a governor. We've had some in the past that might have a friend in business or a donor, and let's say they have one of the large livestock farms where that is going to negatively impact a neighbor. Right? What recourse does that neighbor presently have if you had a governor who pressures an agency to rubber stamp approval and maybe it wasn't done with all the T's crossed and I's dotted? This may be a bill proposed so that that neighbor who's negatively impacted has some recourse. So walk me through that kind of a scenario, because it's not, as you well know, with the corruption we've had historically in Illinois, it's not beyond the pale to say the current system couldn't be gamed to help a donor.
As I mentioned, if you're a neighboring landowner and you're impacted by either the construction or the operation of a farm, you already have a legal opportunity available to you to sue in that instance. You can file an anticipatory nuisance lawsuit if you think that farm is going to be a nuisance to your property. And we do see that on occasion where those suits get filed against our farmers. So there is a legal remedy there that can be used to enforce against either the construction or the operation of the farm. This just adds an additional layer to that particular legal risk that a farmer faces. So now, instead of the nuisance lawsuit, now they could challenge the administrative decision approving the farm. You could go through a lengthy legal challenge there, have to pay for a lengthy legal defense there, and if you're the farmer and say you're successful and that administrative decision is held up by the courts, then you could still face that nuisance lawsuit after that fact. So it's just, again, it's an additional layer there that is unnecessary and simply adds cost and delay to the process.
Mark, can I challenge you on, like, anybody in the world being able to sue? Because, as I understand it, the House bill version is the original one that was proposed. The Senate bill has since been amended to their amendment, right? So, in the Senate, it does limit it to the 5 agencies in the state, but it says that the impact has to be in this state, so to this state's resources. You know, and it stipulates that if somebody wants to file this challenge, they had to have been at the public hearings held about whatever decision that agency was going to reach. The House version, and again, the original Senate version, did say that you could add new evidence, and the Senate bill now doesn't. So, like, how likely is it that somebody in California will file a challenge and say, all these additional cars are going to be put on the road, when they have to come here to have first challenged it in the public hearing, and then they have to prove that in this state's resources are going to be harmed?
The person has to be adversely impacted. And so I think it'd be very likely. I mean, quite frankly, when you look at hydraulic fracking, for one example, and you see 54 or 47,000 comments that came in, that people come in, I think some of these projects, you'll have a huge amount of people that will seek it. And because you can enter new fact patterns and new things, so if the 5 of us decide we're gonna sue, we may each have a different legal argument and bring it forth in the judicial process. It doesn't take but a couple, quite frankly, to go to court to tie this up. And so there's absolutely no doubt about it. As Bill just explained, there is already a process underway for all of these agencies. Whether you're getting a fracking permit, you're getting a sand mine permit, you're getting a CAFO, there is a hearing process by which people can weigh in. There's already the ability, as Bill talked in, about having some lawsuits. This is going to add a whole host of new lawsuits.
Given that there are 2 versions of the same bill, right? Each chamber has a different version. Which one is more amenable to you guys? Like, which one would you prefer to see advance?
Neither,
Why?
because they're both bad for industry.
Like, which one is arguably worse then?
Well, we oppose both of them. I would tell you for the state, for the taxpayers in Illinois, the House version, the original, because that impacted any decision made state or locally. So the amendment limits it to administrative decisions made by 5 agencies. But can you imagine what every county and city across the state, the administrative decisions that they make on a daily basis, and you could have people weigh in for lawsuits? So, I mean, I would argue that would be far worse. But the amendment that I think is moving forward in the Senate bill is equally as troublesome.
Because Senator Rowell said to me today that the Senate bill as it stands now, it's not exactly what it was that he had wanted to achieve, and so that version is not what he's going to be advancing. Does that give you any sort of comfort?
No, we haven't seen any language. We've had communications with him, but we haven't seen any additional language.
So Mark, this would, just to be clear, on one hand, it would impact municipal governments anywhere in the state, right? Not just state government, as far as the regulatory process and approval process.
The introduced bills in Senate Bill 3005 and House Bill 5119 impact every administrative decision made by a state or local government. The amendment in the Senate limits it, Terry, to administrative decisions made by 5 state agencies.
When I had spoken with Representative Anderson this week, he said he hadn't heard from anyone yet, but that he was open to a meeting. But also, additionally, in his bill version, the bill specifically says that only the evidence and facts of the case about surrounding an administrative decision can be weighed in administrative review, at least in that bill, and that nothing on the merits of the case is allowed to be presented as evidence. Does that at all address sort of what you're talking
Well,
about?
I've talked to Steve Anderson about it a couple weeks ago, and he said he was waiting to hear what the Senate was going to kind of do. But they can, as you know, they call it a judicial review. It's not a judicial review, it's a second bite at the apple. Because you can offer new fact patterns, new evidence, things that may not have been ruled originally. You think of a criminal trial or a civil trial today, you know, the appellate court reviews what the circuit court did. Did they follow the law? Did they follow the process? Did they follow the facts? They don't have a whole new separate trial with new fact patterns and everything else. That's what this does. This opens up to a second bite at the apple for all these administrative decisions.
Now, individuals looking at the bill and, you know, the response right here, they might be a little bit confused. Administrative decision, what are we referring to here? I mean, it could be pretty vague to people.
I mean, administrative decision, the 5 agencies issue them all the time. It may be an EPA air permit that is granted. It may be a permit for a livestock operation. Dan's members have to get permits for mines. Department of Public Health, as I mentioned, for example, they regulate parks and campgrounds and swimming pools. So potentially someone wants to build a campground, they have to get administrative approval from the Department of Public Health. If someone alleges that that's going to negatively impact the waters or the lands, somebody could sue over that.
And you said that takes several years at points to go through that process. Is that fair?
Absolutely. In the case of an aggregate mine, you're talking about likely a mining permit, various air and water permits issued through the EPA, zoning approvals. It's quite often a several-year process.
And Mark, I guess you would also argue, if I'm correct, that this somewhat guts the governmental process because even after they make a decision, they can be overruled by a lawsuit.
Yeah, absolutely. I mean, we have a government in place that looks at this. We have experts at all of these agencies. They have to follow the law. They have to follow the administrative rule code. So they have to take all that into account. They're professionals that have done this for decades. This, in some ways, Terry, takes this out of their hands because someone doesn't like an administrative decision that was offered. We're going to go ahead and sue in court using different methodology or different arguments. One last question.
Any thoughts on what this would do as far as the economy, I mean, and how it might slow it down even more?
Bill and others can weigh in, but certainly this is going to add significant time and significant cost. I mean, I think as everyone up here has said, you know, court cases take a while. They could take multiple years, hundreds of thousands of dollars. So certainly if you're a farmer, you're a manufacturer, you're a miner, whomever it is, and you get sued in court, it's going to cost you significant legal costs and significant time. And some companies may choose, hey, we're just not going to do it here. I think right now, back in the day, ethanol plants, you know, in our neighboring states took about 3 months to permit. They took 18 months here. I think the average wait time right now for a Title V air permit at the EPA is about 6.5 years. So again, anything you do to add time and add cost is going to make Illinois less attractive for job creators.
Yeah, I think that's very true for agriculture as well, as Mark mentioned. I think it has a very chilling effect on, say, a farmer's interest in either putting a livestock barn on his farm or expanding his operation or getting some sort of approval from an administrative decision, because if he knows he's going to face a legal environment where he's going to have to defend himself or there's going to be a challenge on that particular administrative decision, he may not be willing to go to that level to do it. So I think it does have a very chilling effect on especially the growth in the agricultural economy for Illinois.
You know, I'm looking at these logos and seeing the people in front of me. It looks like there's a lot riding on this, a lot. And I'm thinking about the everyday Illinoisan either listening to, watching, or reading the stories we're going to put out about it and thinking, well, how does this affect me? The biggest business groups in Illinois came to Springfield to say they don't like this bill because they're watching out for me, the everyday Illinoisan. How?
Well, I think number one, jobs, Dave. Quite frankly, you look at Illinois. I talked about manufacturing jobs. We've added 8,300 since June of 2009. Our neighboring states have added an average of 68,600. They face the same federal challenges, the same global challenges. What's the difference? The Illinois regulatory burdens and the costs that they face here. So this is one more knife in their back, so to speak, and added cost. So there's going to be less jobs here, increased costs. Bill's members, if the cost of producing pork or something else adds additional cost to it, they're going to pay more at the grocery store potentially. So this will add cost to everyday Illinoisans and result in probably less jobs or less job growth in the state. Thank you, everyone.